Maayong hapon, everyone, and welcome to the lecture on evidence for criminology students. So let's start with the definition of evidence. We have discussed in the past that evidence is the means sanctioned by the rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Remember that the main source of law on evidence is the rules of court, particularly rules 128 to 133 or 134 of the rules of court. All right? So, example, si Ivy filed a petition for voluntary insolvency. 'Di ba? Atong nahisgutan before regarding insolvency, let's say insolvent or wala nay assets or kwarta ang usa ka tawo and daghan kay sad creditors. In order for him to be free from his obligations and also to inform the creditors, kailangan mo file siya og insolvency or mo go through siya insolvency proceedings. Okay? So para mahibaw ang mga creditors nga naglisod siya o masabtan siya nga di siya kabayad, kailangan siyang mo file or petition support for either voluntary insolvency or involuntary insolvency as the case may be. So here, ang tanan nga mga nautangan niya, all the creditors naka-receive og notice gikan kang IV nga insolvent na siya. And then katong notice was asking the creditors to file an answer or a comment regarding sa gusto ni Ivy nga i-declare yung kaugalingon as insolvent. Karon ang mga creditors wala ning file og answer or comment. So ang gihimong Ivy ning request siya sa court nga ipadeklarar ang tanan niyang mga creditors in default. Kabaw ko dili mo familiar sa concept sa default because you guys are criminology students, but kaning default ang pasabot lang ani nga kung dunay kaso unya gitagaan kag higayon nga motubag or mo appear sa court unya di ka katubag or di ka ka-appear sa court in a certain period, you will be declared in default, meaning wala na kay katungod nga motubag or mo appear sa korte mao na siya. So ang gibuhat ni Ivy diri because wala ni tubag ang iyang mga creditors in a particular time provided for in the notice nga iyang gisend sa tanang mga creditors, gusto niya nga ipadeklarar nga default ang iyang mga creditors, ang mga iyang nautangan. So, ang question, pwede ba nga mo deny ang court nga, uy, dili na pwedeng ma-declare in default ang mga creditors because ang kanang imuhang gisite nga rule on default is on the rules of court and it does not apply to the insolvency proceedings. Sakto ba ang korte? Kung maingon ng korte, I cannot grant the order of default because the rules of court do not apply to insolvency proceedings. The answer is yes, because here, si Ivy in asking the court to declare his creditors in default is invoking the rules of court. Diba? Yang gibuhat diri, ingon na siya, apply na ng mga rules diha nga naa sa rules of court, which is not applicable because ato na ginang nahisgutan in the past nga the rules of court shall not apply to Nicole. Unsa tong mga Nicole? Naturalization proceedings. We have the insolvency proceedings, the cadastral proceedings, other cases as may be provided by law, land registration cases, and even the election cases. Okay? Unsa may basis ani makita ra gihapon na nimo sa rules of court in Rule 1, Section 4. All right? Now, remember nga evidence is a means sanctioned by the rules of court of ascertaining in a judicial proceeding unsa may iyang i-ascertain ang truth respecting a matter of fact. We have discussed this, that what you need to prove here is a matter of fact, okay? The truth respecting a matter of fact. Now, let's go to some of the terms that you will be encountering in evidence. We have proof, factum probandum, and factum probans. Okay? Kaniya, When we talk about proof, mo ni ang result or the effect of evidence. Factum probandum is the ultimate fact or the fact sought to be established. It is the fact to be proved, and then factum probans is the evidentiary fact or the fact by which the factum probans is to be established. Kaning yung mga concept, we will be discussing this later on after aning kaso nga akong ipakita ninyo. Kaning nga case also talks about the applicability of the rules on evidence with administrative proceedings. Unsa man ang administrative proceedings kanang mga pananglitan kanang case sa dole, which ang example ani kaning Bantolino versus Coca-Cola Butlers. Ako ni ipakita ninyo ang sinahitabuan niya na ay 62 ka employees of the Coca-Cola company ning file sila complaint for unfair labor practice. Kanang unfair labor practice dunay gihimo ang employer nga nakalapas sa labor code. I'm sure inyo nang makatunan later on as you progress in your study. But kining kasuha, ning file ang 62 ka employee sa Coca-Cola og complaint for unfair labor practice. Kaya nga naman, allegedly, ang mga employees ko in the performance of their duties as route helpers, bottle segregators, and others were replaced and prevented from entering the company premises. Giilisan daw sila and wala na sila pasudla sa company premises. And such act by the employer is deemed an illegal dismissal according to the 62 employees. The company, in this case, niingon ang Coca-Cola nga walay employer-employee relationship. Busa, wala po'y katungod ang labor arbiter nga mudawat aning kasuha. Mo'y giingon sa Coca-Cola. So unsa may gihimo sa labor arbiter, ang labor arbiter muning mag-decide ha sa ilang kaso. Ang labor arbiter nag-render og decision in favor of the employees and ordering the company to reinstate the complainants to their former positions with all the rights, privileges, and benefits due to regular employees and to pay them full back wages. So ang gibuhat sa Coca-Cola, of course, ni-apilar sila sa decision ngadto sa NLRC, which sustained the findings of the labor arbiter. Bisag ni-appeal sila sa NLRC, giuyunan sa NLRC ang desisyon sa labor arbiter. So ang gibuhat ron sa Coca-Cola, ning adto na pud sila sa Court of Appeals. Apan, ang Court of Appeals ning affirm gihapon sa desisyon og sa giingon sa labor arbiter nga dunay existence of employer-employee relationship. Pero giset aside niya ang favorable decision on the part of 7 employees for lack of sufficient evidence. Niingon ang Court of Appeals here nga ang affidavit kuno sa 7 ka employee should not have been given probative value for their failure to affirm the contents thereof and to undergo cross-examination. So niingon ang Court of Appeals, since kaning 7 ka mga employees of the 62 employees, since ilang affidavits gipresentar nga to labor arbiter without presenting them and without undergoing cross-examination, dito siya dapat admiteron as evidence. So, niingon ang Court of Appeals, only those 3 employees were declared regular employees since they were the ones only subjected to cross-examination. Now, ang issue here is whether or not ang affidavit should be given value despite the failure of the affiants to affirm their contents and undergo the test of cross-examination. Niingon ang Supreme Court here, guys, nga the rules on evidence are not strictly observed in proceedings before administrative bodies like the NLRC, where the decision may be reached on the basis of position papers only. It was not necessary for the affiants kuno to appear and testify and be cross-examined, as it would negate the rationale and purpose of the summary nature of the proceedings mandated by the rules and to make mandatory the application of technical rules. So going back to the general principle, timan that the rules of court or the evidence or the rules on evidence do not necessarily apply to labor cases or administrative proceedings, okay? And also, katong mga gihisgutan nato ganiha ang Nicole, okay? Kaya nga naman, generally, because evidence is a means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Okay? So remember that. So remember the doctrines here, no, nga ang rules of court, specifically ang rules on evidence, does not strictly apply to an administrative body performing quasi-judicial functions. Also, kaning uban diri nga mga principles is not relevant to your study because very technical man ni. Now we go to the concept of factum probans versus factum probandum. Kung moingon kag factum probandum, di ba, ito na pong ni-discuss initially last meeting, nga mauni ang fact or proposition to be established. Ha? The fact or proposition to be established. Ang facts or material evidencing the fact or the proposition to be established is what we call the factum probans. Ang factum probandum is the fact to be proved, the fact which is an issue unto which the evidence is directed. Ang factum probans, ang probative or evidentiary fact tending to prove the fact in issue. Ang factum probandum is the ultimate facts. Ang factum probans, intermediate or evidentiary facts. And when we talk about the factum probandum, hypothetical na siya. Ang factum probans, existent. Okay? Ang example, ani kini, kung pananglitan si Ivy, ni-claim siya to have been injured by negligence of, let's say, Kenrick, who denies having been negligent. The negligence is the fact to be established. Mao na ang factum probandum. Ang kailangan nimong iproban or probaran nga tinuod, mao na ang factum probandum. The evidence offered by Ivy in this case constitutes the material to prove the liability of Kendrick. Okay? So mao na siya ang gitawag natog factum probans. Ang ebidensya nga iyang gamiton, mao nang factum probans. Okay? Factum probandum is the fact or the proposition to be established. Factum probans is the facts or material evidencing the fact or proposition to be established. Example. X gipasanginlan nga iyang gipatay si P. Okay? So karon ang pamilya ni P ningkiha nga gipatay ni X si P. Factum probandum na ba na ang pagpasangil nga gipatay niya si P? Dili pa. Because later, pwede man nga nag-array niya ang kunon ni X nga iyang gipatay si P. Diba? So, ang atuan ng mahibaw-an ng factum probandum the moment i-array na siya. Kanang basahan na siya sa iyahang kaso niya, pangutan-on siya sadaan ba siya or dili. The moment mo ingon siya nga dili siya sadaan, that's the time that factum probandum will come in. You will now establish the fact or the proposition that indeed si X dire gipatay or si P dire ang nipatay or si X dire gipatay niya si P. Okay? I hope klaro lang na ha. Factum probandum and factum probans. Okay. Now, we also discussed this, that the rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. We now go to admissibility of evidence. This is one of the rules nga giamendar sa Supreme Court, guys. Sa una, niingon ra ni nga evidence is admissible when it is relevant to the issue and not excluded by law or these rules. Karon, gipuno sa Supreme Court, ang evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or these rules. Now, you might ask, kanus adi ay admissible ang evidence, attorney? We have already discussed this nga ang evidence is admissible when it is relevant and when it is competent. Okay? When it is not excluded by the law or the rules, therefore it is competent. Okay? Kanus aman siya relevant? It is relevant when it has such a relation to the fact and issue as to induce belief that it's of its existence or non-existence. It is also competent if dili siya nakalapas sa Constitution, sa law, or sa rules. Okay? Ang competency, guys, of evidence, ma-determine na nimo by the exclusionary rules of evidence. You can determine this by law, by the Constitution, by the rules, okay? Ang relevancy on one hand is an affair of logic. Imuhag yun ng pagsabot. It's a matter of logic. It's a matter of human experience and common sense, while competency is determined by law. Okay, you have to remember that. Now, also remember, katong giingon before nga illegally obtained evidence cannot be admitted because they are the fruit of the poisonous tree. Example of illegally obtained evidence or evidence obtained without a valid search warrant, okay? Or even without a warrant, okay? Also remember that this section could also be the answer to the question on the two kinds of objection. That is, objection that the evidence is not relevant to the issue or relevant to the issue, and that secondly, it is excluded by the rules. Basically, ato lang nang gi-summarize in a nutshell. Again, remember that an evidence is admissible when it is relevant to the issue and when it is not excluded by the law, by the Constitution, and by the rules of court, meaning it has to be a competent evidence. Okay, example ko no, kaning kasuha. This is entitled People versus Aminuddin. Okay, sikat kining kasuha sa una. Ang naitabo ani, si Idil Aminuddin was arrested after disembarking from MV Wilcon 9 in Iloilo City. Ang PC ba na sa una, Philippine Constabulary pa man ng mga police officers before. The Philippine Constabulary officers who were in fact waiting for him accosted him, inspected his bag, and finding what looked like marijuana leaves, took him to their headquarters for investigation. Karon, katong 2 bundles of suspected articles were confiscated and tested by the NBI laboratory. They were verified to be 3 kilos worth of marijuana leaves. An information for violation of Dangerous Drug Act was filed against him. Karon, si Aminuddin was eventually convicted. Niingon ang prosecution in this case nga the Philippine Constabulary officers had earlier received a tip. Ang basis nila nung gidakop nila si Aminuddin because of a tip from one of their informers naming accused appellant or naming Aminuddin and adding that he was on board the said vessel and was carrying marijuana. Ang PC, naghuwat niya, kunya giduol siya, pag naog na niya, after ang informant niingon nga mauna siya, sir, ay muna sa Aminuddin, muna nagdag marijuana. So pag naog niya gis barko, gitudlo sa informant ngadto sa PC nga muna sa Aminuddin nagdagbag, muna siya ang nagdag drugs, kana dakpo na. So from there gidakop sa PC mo nay ingon sa prosecution. Si Aminuddin on one hand during the hearing niingon siya nga dito akong marijuana, and he alleged that he was arbitrarily arrested and immediately handcuffed. His bag was confiscated without a search warrant, and that the PC headquarters where he was mishandled to force him to admit, and that he insisted he did not even know what marijuana looked like, and that his business was selling watches and sometimes cigarettes. He also argued that the marijuana he was allegedly to have been carrying was not properly identified and could not have been of several bundles kept in the stock room of the PC quarters. So, ang trial court in this case, wa sila na-convince, mao na nga naabot ni sa Supreme Court. So, ang issue, ani, kay whether or not the arrest was legal and the evidence was admissible. Unsa man kahay nahimong desisyon ani sa Supreme Court? Niingon ng Supreme Court, no and no. So the arrest was not legal, meaning it was illegal, and the evidence was not admissible. It was inadmissible. Nga naman, niingon ng Supreme Court, it is admitted by the PC officers who testified for the prosecution that they had no warrant when they arrested Aminuddin and seized the bag he was carrying. So kani, niingon daan ng Supreme Court, kamo mismo PC officers ning testify mo nga wa mo'y warrant pag-arrest ninyo ni Aminuddin niya pagkuha ninyo sa bag niya. And ang inyong yung justification was the tip you had earlier received from a reliable and regular informant who reported to them that Aminuddin was arriving in Iloilo by boat with marijuana. Further, niyon ng Supreme Court, there was no warrant of arrest or search warrant issued by a judge after personal determination by him of the existence of probable cause. The accused appellant was not caught in flagrante, nor was a crime about to be committed or had just been committed to justify the warrantless arrest allowed under Rule 113 of the Rules of Court. Even expediency could not be invoked to dispense with the obtention of the warrant. The present case presented no urgency to apply the ruling that vessels and aircraft are subject to warrantless searches and seizures for violation of the customs law because these vehicles may be quickly moved out of the locality or jurisdiction before the warrant can be secured. Further, ang Supreme Court niingon from the conflicting declarations of the PC witnesses, it is clear that they had at least 2 days within which they could have obtained a warrant to arrest and search Aminuddin, who was coming to Manila on the MV Wilcon 9. From the information they had received, ng Supreme Court na apa mo'y duha ka adlaw mukuha unta sa warrant of arrest o warrant or search warrant, pero wala niyo gikuha. From the information they had received, they could have persuaded the judge that there was probable cause, indeed, to justify the issuance of a warrant. Yet, wa ninyo buhata ninyo ng Supreme Court. So, no effort was made to comply with the law. The Bill of Rights was ignored altogether. The constitutional presumption is that he is innocent and he will be so declared even if his defense is weak as long as the prosecution is not strong enough to convict him. Ningon ng Supreme Court, without the evidence of the marijuana allegedly seized from Aminuddin, the case of the prosecution must fall. That evidence cannot be admitted. So mo na niya akong giingon in the past, di ba, nga mga illegally obtained evidence, mo na di na siya magamit sa korte. So kung wa na siya, there can be no conviction. The marijuana was seized illegally. It is the fruit of the poisonous tree in the Supreme Court. And that the search was not an incident of a lawful arrest because there was no warrant of arrest and the warrantless arrest did not come under the exceptions allowed by the rules of court. Hence, the warrantless search was also illegal and the evidence obtained thereby was inadmissible. With the exclusion of the illegally seized marijuana as evidence against the accused appellant, his guilt has not been proved beyond reasonable doubt, and he must therefore be discharged on the presumption that he is innocent. The decision of the trial court is reversed, and the accused appellant is acquitted. So you have to take note of that, okay? The admissibility. You have to take note of the concept of admissibility of evidence. So it has to be competent, meaning it should not be excluded by the rules of court, by the Constitution, or by any other law. Otherwise, di gyud na ma-admitter nga ebidensya bisan pa og illegal na siya. Okay? Just remember that, the concept of fruit of the poisonous tree. Now, there are certain types of admissibility of evidence. We have the conditional admissibility of evidence, maunang evidence that will be admitted, although seemingly not admissible, provided that its relevancy would be shown in a later stage of the trial. Ikaduha, curative admissibility of evidence, evidence which will be, ako lang na i-run through, dili kayo ni siya, I think I haven't seen them much in your exams, but I will just run through this para na mo idea. Curative admissibility of evidence, evidence which will be admitted, although normally inadmissible because similar inadmissible evidence has been introduced by the other party. Multiple admissibility of evidence, when the evidence not admissible for one purpose, but admissible for two or more purposes. We have also the concept of plain view rule, diba? Ato na sa rin na-discuss in our last meeting na under this doctrine, mga unlawful objects within the plain view of an officer who has the right to be in the position to have that view are subject to confiscation and are admissible in evidence. Okay? Example, nagukod ka og usa ka fugitive of justice. Gigukod nimo si X usa ka police officer, let's say Ivy is a police officer, gigukod niya si X, and then in the pursuit of X nakasud sila sa usa ka building baron nga open, dito ning tago si X. Pagsud dito ni Ivy sa building to pursue X, kita siya dito sa table og mga marijuana, and there were also several people there naghit-hit og marijuana. Can Ivy also arrest those individuals? Yes, because it was under the doctrine of plain view. Okay? Nga naman, Ivy had the right to be there because she was in the pursuit of X, and the discovery of the items of the marijuana was actually in plain view. So pwede niya nga maaresto ng mga tao in that particular building. Now, exclusionary rule. This is a rule of evidence that excludes evidence obtained in violation of one's constitutional rights or obtained through illegal means, such as those obtained by tortures and the like. Muna akong giing gyapon gini ha, nga ang ebidensya has to be competent, meaning it should not be excluded by the rules of court, by the Constitution, or by any other law. Otherwise, the exclusionary rule will apply. Okay? Katong fruit of the poisonous tree, ato nang gisgutan gini ha, kani nga doctrine simply states that once the primary source, the tree, is shown to have been obtained unlawfully, any derivative evidence the fruit derived from it is likewise not admissible. Katong kaso ganihang atong gisgutan, katong kang Aminuddin. Ang tree ato is the arrest itself, di ba? The act of arrest of Aminuddin. Walay warrant, that's already the tree. The tree is poisonous. Illegal na to, unlawful na to siya. So whatever fruit that comes from that tree is also illegal. So whatever ang imong makuha nga ebidensya because of that arrest is illegal. So the evidence illegally obtained by the state should not be used to gain other evidence because the illegally obtained evidence taints all evidence subsequently obtained. Okay? I hope nakuha niyo yung concept. It could probably come out in your exams, but it's your exams manggod is basically multiple choice. So you need to familiarize the concepts. Kaya palitan mo yun, this is a doctrine that states that once a primary source, etc., etc. Is it A, exclusionary rule, plain view rule, fruit of the poisonous tree, silver platter rule? So basically, you need to choose the best answer, and the best answer would be fruit of the poisonous tree. So munang kailangan inyong memory should be very good at that. Okay? And then we have the silver platter rule. This doctrine now discredited, is already no longer followed in the US. This allowed the evidence seized by the state officers in a legal seizure to be used against the accused in a criminal trial. This is not applicable in our jurisdiction, but this used to be a rule that is applicable in the USA, but no longer applicable here. So this is just a matter of knowing some of the rules that you could come across in your practice when you become police officers. Relevancy, just a matter of reading, and then we now go to matters which need not be proved. There are facts that doesn't have factum probandum. Di na kakailangan mag-factum probandum because recognized na siya by court. This is already acknowledged by the court to have been in existence, okay, or in existence, to have been existing for the long run already. So di na nimo kailangan og ebidensya to prove it. So unsa man eh? This is section 1, rule 129, judicial notice when mandatory. When you talk about judicial notice, mauni ang cognizance of certain facts which judges may properly take on without proof because they already know them. It's a presumption that because these matters are mandatory for judicial notice, ang mga judges kibaw na ani hindi na kailangan mo demand og evidence to prove it. Okay? So unsa man ni ang mga things which the judicial notice is mandatory. The following: a court shall take judicial notice without the introduction of evidence of course, the existence and territorial extent of states. Di na mo kailangan i-probar nga na United States, na Spain, na Philippines. Okay? Political history, you don't have to prove that we had 1935 Constitution or 1937 Constitution, I forgot, or several constitutions in the past. You don't have to do that. forms of government and symbols of nationality, the laws of nation, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, the official acts of legislative, executive, and judicial departments of the Philippines, and then the laws of nature, the measure of time, and the geographical divisions. Kani nga mga butang, you don't have to prove it. Kaya nga naman, it's presumed nga the courts will take judicial notice of these one. Kaning, di ba, ay kung ina, you have to prove nga pananglitan si X nahulog, namatay. You don't have to prove nga ang usa ka butang pwedeng mahulog because laws of nature is already of judicial notice. Mandatory na ang judicial notice ana. Then mo kailangan iprobar nga ang Pilipinas is a republican and democratic country because it's already of a judicial notice, di ba? Di na mo kailangan iprobar nga na ay Luzon, Visayas, and Mindanao because the geographical division is of judicial notice. Mandatory ang judicial notice ana niya. Okay, so you have, inyo lang buhaton is to basically memorize, perhaps commit to memory the instances wherein judicial notice is mandatory. Kani sila, okay? Kanya na po yung mga butang, ang judicial notice is a matter of discretion, kanang of public knowledge, capable of unquestionable demonstration, or to be known to judges because of their judicial functions. Okay? So you have to make a distinction na ay mga judicial notice mandatory, meaning di na kailangan of proof, kaning judicial notice nga discretionary, pwede nga mo take judicial notice ang korte, pwede sad nga mo demand siya og ebidensya kay discretionary man on the part of the judge. Okay? And then, okay, let me just read this, okay? Kanilang, judicial admissions. An admission, when we talk about judicial admission, this is an admission, verbal or written, made by the party in the course of the proceedings in the same case and does not require proof. The admission may be contradicted only, showing that it was made through palpable mistake or that no such admission was made. Okay? So this is another situation wherein ang ebidensya dili na kailangan nimong ipresentar. Okay? Evidence is no longer required. This is in cases of judicial admissions. But na exception, pwede nga imuhang ipaprobar gihapon nga tinuod imong judicial admission kung there's a palpable error or palpable mistake. Nasayop lang gid ka ba? Nasayop lang gid kag sulti pananglitan the case of pananglitan ako mayon ko ron lalaki ko. And then nasayop lang yung sulti, slip of the tongue. And then you would say in court, IV, if kontrata mayon ka, di na nimo dili na ka pwede nga mo deny ana nga lalaki ka because you already admitted that you were a lalaki. But it's just a palpable mistake. So I can always deny it because it was made through a palpable mistake. Babae man ko pero slip of the tongue nakain ko lalaki ko. Okay? Also, if there was no admission made, ang pasabot lang ani nga ang nagsulti sa admission kay dili mao yang pasabot ba gilain og sabot. Okay, it was taken out of context. Pang artista ba mana, that is not what I meant mana. This is what we call no admission was such made. It doesn't mean nga wa gid siya gisulti nga admission, but he could have uttered something but it was taken out of context or it was not what he actually meant during the admission. Okay? And also remember, kaning gitawag na tog judicial admission has to be in the same case. Dili pwede sa lain nga kaso. Kay pwede man, di ba, magdungan-dungan na kay kaso diri sa branch 1, na kay kaso sa branch 2. In branch 2, you admitted something. That admission cannot be used in the case sa imuhang branch 1. Okay? Pananglitan, kani, si Ivy, gi-admit niya nga siya nagamit og bazooka to kill, let's say, Z. Ngadto sa police. And siya, police, mamang police, I was actually the one who make bomb or who bombed via a bazooka Z and killed him. Question, will that confession be used by the prosecution or can that confession be used by the prosecution and say di na ba kailangan ang factum probando, meaning di na ba niya kailangan No, because it has to be corroborated by evidence on corpus delicti. Remember, in criminal cases, dili enough nga ning admit lang ang akusado. Okay, nag-admit lang siya ang akusado. It's not enough that he admitted the commission of a crime. It has to be accompanied and corroborated by evidence on corpus delicti. Unsa man din ang corpus delicti? When we talk about corpus delicti, ang literal lang yun ang meaning kay body of the crime, di ba? When we talk about corpus, it's body, delicti is crime. So, body of the crime. It is the actual commission by someone of the particular crime charged. It refers to the fact of the commission of the crime, not to the physical body of the deceased or to the ashes of burned building. The corpus delicti may be proven by the credible testimony of a sole witness, not necessarily by physical evidence. Nine elements ang corpus delicti, kaning proof of the occurrence of a certain event and a person's criminal responsibility for the act. Now, na example dire wherein ang principle on corpus delicti actually applied. Now, remember ha, dili ni pasabot nga ang corpus delicti refers to the physical body of the deceased kung murder na or homicide na or parricide na, as the case may be, or ashes of the burned building if it's arson, okay? It refers to the actual commission by someone of a particular crime charge. And it refers to the fact of the commission of the crime. Okay, the fact of the commission of the crime. So let's look at the case of People versus Unsung. Okay, so People versus Unsung, sometime in October 1949, kani si Unsung complained to the chief of police of Maluso that Mo Roberto was taking away the coconuts from his Unsung's property or plantation, from his plantation. The chief of police told him to complain to the provincial fiscal. Upon si Unsung wasn't able to see the said officer. So Seberto continued picking up the coconut fruits, claiming that he was the owner of the plantation. So sige siya panguha gyapon dito. Now on October 7, 1949, si Jubel, the foster son of Unsung, went to the seizure of Sangbay, Basilan City, Zamboanga, and there saw Morosberto, Abdani, Ika, and Kasim loading 7 sacks of copra gathered from the plantation. Okay? Jubil asked Berto what he was doing or what he was going to do with the copra. And then niingon si Berto nga iya ko nung dadon dito sa Isabela. And then moto ang iya si Berto ngayong kauban nga tulo katong uban nga mga Moros niadto na dayon atong sa Isabela. I mean sailed to Isabela. And then a few days afterwards, si Abdul Samad saw Jubail with Jaho boarding another Vinta, Jubail carrying with him 3 homemade bombs or hand grenades. Okay? Kinamdum mong Jubail? Si Jubail ang foster son ni Unsung. Okay? So mga pila ka adlaw anak, nakita ni Samad, Abdul Samad, si Jubail, kauban si Jaho, nganing sakay og Vinta, murag baruto ba? Nya iyang gida, kay tulo ka homemade bombs or hand grenades. So, when Moro Wahina asked what those objects were, si Jubel answered that they were homemade bombs which they were going to use for fishing. So afterwards, si Jubel and Jaho sailed away. Kung na sila dito. Na when they returned to Sangbay, Samad and Wahina noticed that they no longer had bombs and that they did not bring any fish. Okay, nabantayan nila, pagbalik nilang Jubel og ni Jaho nga wala na ang bomb niya, wala po sila nga fish. So from that time, si Berto po, si Abdani, si Ika, o si Kasim have not been seen or heard from anybody. Okay? So kad atong nangisdakin tayo silang habil, ang katubo silang Berto, nga netong Isabela, nga padung na unta uli, nga to silang lugar, wala po makit eh. Okay? So si Abdul Samad saw pieces of Berto's Vinta in the seashore of the island of Pilas. So kato si Abdul Samad, nakita na niya ang mga pieces sa barko or Vinta ni Berto. So when the authorities were apprised of the disappearance of Berto and his 3 companions and discovery of the wreckage of Berto's Vinta, they began to make an investigation. So ilang gi-arrest karon si Unsung, si Jubel ug si Jaho. Okay? Karon si Unsung ning confess siya. Nya ningon siya nga si Berto and his companions had taken away copra from his plantation, and then iyang gi-order ang iyang foster father. He ordered his foster father. He gathered 3 home bombs and Jaho to sail with him, telling the latter that they were going to fish. Foster's son. With Jaho as helmsman, they followed the Vinta of Berto, which had sailed ahead. Upon reaching a point about 7 brazas distant, Berto's Vinta, he, Hubel, ignited the bomb one by one and threw them successively at Berto's Vinta, causing them destruction. So ilak gilabay og bomba. They said they sailed back and kept silence as to what they had done. Si Jaho also made a written confession stating that gi-invite siya ni Hubel to go fishing with dynamite. He acted as helmsman, and upon instruction of Jubail, they followed the Vinta of Berto. When they came near to it, to his surprise, he saw nga si Jubail was throwing bombs or hand grenades at the Vinta. He told Jubin that he had known, or had he known that that was the purpose, he would not have accompanied him. Before going with Hubel, he believed that they were going to fish and had no idea at all that Hubel intended to commit a serious crime. So at the trial of the case, si Unsung, si Jubel, and si Jaho did not assail the validity of their respective confessions, confining themselves to a general denial of the crime charged. They did not say that they were forced, tortured, or given the promise. So, ang kaning mga sa silang Jubel, ning contender nga dapat walay conviction because it cannot be based on an extrajudicial confession with proof of corpus delicti. Ilhang contention ato man napalgi ang mga lawas nilang Berto. Ha? Unya, ningon ng court, that is true, but in the present case, the corpus delicti is shown in the following facts established by evidence independent of the confession. Unsa man ni? Jubel was the foster son of Unsung, or the grudge against Berto. Jubel and Jaho were seen by Samad and Mahina sailing from shore of Sangbay. Jubel carrying 3 hand grenades. So basically, dili lang katong ilang confession or admission ang gisulti. It was also corroborated by other evidence such as testimony atong Samad o ni Wahina ug ang pag-establish niya indeed wala na gyud silang Berto, although there was no discovery of the body. Okay? Then when Jubel and Jaho returned, they no longer had hand grenades nor did they bring any fish. The pieces of the wreckage of Berto's Vinta were also seen in the shore on the island of Pilas. Berto and his companion must have met a violent death due to the commission of the crime. So, ningon ng Supreme Court in the case of U.S. versus Valdez, the court said that the work of raising the anchor seems to have proceeded slowly to satisfy the accused, and he accordingly began to abuse the men with offensive epithets. Upon this, Venancio Gargantel remonstrated, saying it would be better that they would work together if he would not insult them. The accused took his remonstrance as a display of insubordination. In raising in range, he moved towards Venancio with a big knife in his hand, threatening to stab him at the instant when the accused had attained to within a few feet of Venancio, the latter evidently believing himself in great and immediate peril, threw himself into the water and disappeared beneath its surface to be seen no more. So in this case, ningon na Supreme Court, kaning kasuha, kaning ilang Jubil, ilang Unsung, the accused did not stop the deceased, jumped into the river and was seen no more. The conclusion was that he died. This is the corpus delicti. The evidence of corpus delicti in that case is similar to that in the present. Okay? So, ang ebidensya kuno atong kaso sa US versus Valdez o kaning kasuha karon sa People versus Unsung, pare-pareha sila kaso. So, ang katong conclusion nga there was indeed death is already corpus delicti. The fact that there was already death, the fact na ilahang gibumbahan, the fact na nahabilin kay ang guba na lang nga binta, that's already corpus delicti. Okay? So ningon na Supreme Court, in view of the foregoing, the decision appealed from is affirmed with modification that the indemnity should be raised to 6,000 gamay pa kayo with cost against the nila ni Unsung and the other accused. Okay? So we stop at Rule 129 on our okay, kanilang nalang ko i-add, okay? Nalang ko i-add. Remember lang in case of kaning violation of Illegal Drugs Act ba, kung wala gani ma-identify nga drugs, Okay? Kung wa gani ma-identify nga drugs, walay mahimong conviction, okay? No drugs identified beyond reasonable doubt, there's no conviction. Meaning, kung ikaw mapulis mo pohon, you have to identify the very drugs nga imuhang na-confiscate during the bypass operation, say sa bypass operation, okay? So, kung ang kaso gani is with respect to drugs, kailangan ang imong ipresentar nga corpus delicti is the drugs nga imuhag yung na-confiscate, okay? With respect to drugs, remember the corpus delicti includes the identification of the drugs because the corpus delicti includes the drugs itself. Okay? Also, in cases of robbery and theft, it can be proven that there was indeed an unlawful taking, or so long as it can be proven that there was indeed an unlawful taking na ay pagpanguha ng unlawful, bisan pag wala na makita ang gikawat, ha? There can still be a conviction for theft or robbery. All right? So in theft or robbery, bisan pa o di na makitaan ang ebidensya or ang gikawat nga butang, as long as you can prove that there was indeed an unlawful taking, there can still be a conviction for theft or robbery. I hope inyuhan ng mahinumduman karon na amoy nakatunan karon sa atong gi-discuss, and I'll see you guys on Saturday, sunod nga Saturday, and I hope nga musayo-sayo na mo para maka-klase ta og live. Okay? Thank you very much, Amping.